Right. Welcome, everyone, for our fourth and last 3CL seminar in Lent term. It's a great pleasure to have Professor Alberto Saiz Garitaonandia today with us. He's joining us from the University of the Basque Country, where he is a professor of procedural law. Professor Saiz Garitaonandia served as director of the Basque government legal department as a Solicitor General from 2013 to 2020. He is currently a visiting fellow in Clare Hall at this university, and also a visiting scholar at 3CL, that is our Center for Corporate and Commercial Law. He is currently researching in the area of artificial intelligence applied to dispute resolution, and that is what your seminar will be about. It is titled Artificial Intelligence and Dispute Resolution, Challenges and Limitations. Alberto, it's a great pleasure to have you here today, and I'm looking forward to your presentation. Thank you.
Thank you, Felix. Well, first of all, thank you to the Center for Corporate and Commercial Law for giving me this opportunity to deliver this seminar, and for giving me the opportunity to spend a year here, invited in the University of Cambridge. Felix, you are the real expert on this topic. You should be here giving this seminar, but anyway. And of course, thanks to my colleagues too, because they gave me the fellowship, which makes me possible to be here too. Well, before starting, let me make a brief overview of the presentation. First of all, I will give you an introductory idea of the impact of AI in the judicial area, and then we will mention some experiences of AI predicting judicial outcomes. And after this, we will move to the main issues regarding the use of AI in the judicial area. First of all, we will mention bias. And here, to illustrate bias, I will use some examples. The first one will be the Second World War fight planes, and then ski jumping and hungry judges. And then we will talk about explainability as one of the main issues regarding the use of AI, not only in the legal area, in the judicial area, but overall speaking, in so many areas. After that, I will mention an idea of a possible integration of AI in the judiciary, and I will illustrate this case. I will illustrate this with an example about the best tennis player in history, who, as you know, is Rafael Nadal, and then I will move to the final conclusions and drop some conclusions. Well, as an introduction, until recently, when we talk about innovation and the use of technology in the judicial area, we were talking about adapting or adopting new technologies to continue doing the traditional work without changing the court's operations, following the same processes and trials. For instance, we were talking about digitalizing the documents. We were talking about the possibility of sending the documents and receiving the documents in a digital way. And even with the pandemic, we saw how in some jurisdictions, in some courts, here in UK, also in Australia and Spain too, we started using videoconferencing in the trials because it was not possible to be there in person. But as mentioned, it was the same traditional work, but done in a different way, more technological way. But now, with AI, we can create algorithms to enable decisions to be made. Machine learning tools can process large amount of data, and they have the ability to make their own predictions. And this is a game changer, because we are not talking about doing the traditional, the old job, but something transformative, disruptive. And the importance of AI in dispute resolution lies precisely in its potential transformative nature, which may even have implications in the structure of the judiciary. Well, AI and its use in the area of dispute resolution is a very broad topic. We could talk about using AI in mediation, for instance. In fact, I read one paper about using it to detect parties' feelings through the micro movements of the face, or even in arbitration. But today, I will focus on the possibility to implement, to deploy a robot judge, an AI judge. And under what circumstances could we do it? What problems and limitations would it have? Well, first of all, we must check if the current technology, the state of the art, allows us to think about it, or if it's just science fiction. Well, there have been so many researchers predicting the outcomes of processes in different places, in different courts. I've read so many papers about this from Philippines, Thailand, France, Germany. And these three are the most cited ones, I would say. And in fact, these three have been used as benchmark for some others. And that's why I am showing you these three. And today, I will want to focus especially in the accuracy of these experiments, of these experiences to predict the judicial outcomes. And as you can see, well, there are different levels of accuracy, but some of the results are really promising. Some of the algorithms were able to achieve more than 90% of accuracy predicting the judicial results. And we have to consider that machine learning is evolving very fast. So in some years, we may have even better results. And with these current levels of accuracy, well, it is not inconceivable that in the future we can see an AI judge. But let's see the main issues. Let's move to the main issues regarding the use of AI in dispute resolution. We will mainly focus on bias and explainability. Well, first, bias. It is said that the outcomes produced by AI may be biased. But where can this bias come from? Well, the first origin may be the dataset, the information we provide the algorithm to train, learn, and make its correlations in order to give us the output. And this dataset might be biased for several reasons. First, because it is incomplete, because it is not a good representation of the world it wants to apprehend. Let me show you an example about this. During World War II, Allies were trying to minimize aircraft losses in combat. And in order to do so, they tried to find patterns in strategic locations of the planes so that they could place additional armor on them. And they started to analyze the planes coming back from battle with bullet holes. And they found the areas apparently most commonly hit by enemy fire. And here, in this picture, you can see the data they collected from the planes. This was the data set they had. However, one person, Abraham Wald, pointed out that they might look at the data from another point of view. And he suggested that the reason some areas of the planes weren't covered with bullet holes was that planes hit in those areas did not return. And this insight led to place the additional armor to reinforce those areas without bullet holes. My point here is that sometimes there is missing, non-obvious data that is meaningful for our analysis. And bringing this example to the judicial area, if we want to complete a data set of judicial issues to build a predictive algorithm, do we have to consider all the decisions taken by the judges? Or maybe only those not appealed? Or maybe we should also add those appealed but dismissed? And what about the similar cases solved by arbitration or mediation? Or plea bargaining, when applicable? Well, my point here is that we have to be aware of the possible gaps in the dataset. And as you can see, there are some questions we have to answer before building a good dataset. And these questions cannot be answered by computer scientists. Lawyers and some others, conforming a multidisciplinary team, have to take part in the definition of the dataset. And we have to find the best way to capture the reality. So we have to harvest, clean, and organize the data to get this picture. In fact, 2 weeks ago, we were here listening to a US professor talking about the inaccuracy of the data set used by the G index. Well, and apart from being incomplete, the data set can also contain biased information. So it will produce biased outputs too. I will try to illustrate this with an example I read some weeks ago from a research carried out by Kramer, Otto, and Pawlowski about ski jumping. To be honest, coming from Southern Europe, I didn't know almost anything about this sport discipline. I thought everything was about jumping as long as possible. But it is not. The style of the jump also matters. And this style is judged by 5 judges from different nationalities. Well, the researchers analyzed more than 15,000 ski jumps in men's top-level competitions from 2010 to 2017, Olympic Games, World Championships. And they concluded that nearly half of the judges favored jumpers from their nationality in a way that was statistically transcendent. And that this bias, which is called nationalistic bias, differs in a significant way by country. In fact, they even went beyond by making a relationship between this nationalistic bias and the level of corruption of the countries. But we are not following this argument today. Anyway, according to some calculations, if we eliminate this bias, 2.3% of the medals would have changed hands. So 2.3% of the final outcomes would have been different. And if we were talking about trials or processes, 2.3% of the final sentences would have had a different outcome without this human bias. And we are feeding the AI with this biased information. And moreover, in their paper, Kramer, Otto, and Pawlowski say as follows: it is important to note that our results were obtained from fully observable sports competitions, and therefore, such an in-group favoritism may even be stronger in less transparent settings that involve subjective decision-making, such as policy-making processes, judging in legal proceedings, human resource management, etc. We might not agree with that, and we may think that this happens in ski jumping, but not in the formal judiciary, not in the formal judicial branch. But let me show you another study made in Israel regarding parole boards so that we can understand the impact of the human bias. Danziger, Levav, and Ain Peso, the scientists, were following the activity of 8 judges presiding parole boards in Israel in more than 1,000 cases. At the time of the research, these parole boards made 2 daily food breaks. And as you can see in the graphic, at the start of the day, the judges were like in good mood and granted between 65 to 75% of the applications. But as the morning went by, chances of being released in parole reduced dramatically up to 0. Then, after the first food break, the possibilities grew again, up to 65%. And as the hours passed, the approval rate fell again. And the same happened after the second pause, the lunch break, until the end of the session. With this, I want to suggest that, first of all, human judges are subject to factors that can make their decision biased, both mental and physical factors. With AI, we can detect some of these biases and improve the administration of justice. But at the same time, we have to be aware of something, that the information we have available to feed and train the AI, even the judicial decisions, may be biased. And when we detect a human bias, we must choose if we want to keep it or remove it. But we have to take into consideration 2 elements here. First one, the more information we take away from the dataset, let's say gender, race, address, whatever, then the less accurate the algorithm will be. And secondly, and more importantly, in my opinion, behind these decisions of removing information from the dataset, there is a social or political decision that has to be taken. We might be talking about race, bias against women, or bias against men, or any other bias. But removing this information is not a technical decision. It is a social political decision. because this decision means that we are modifying the reality we currently have. And this is a serious decision with potential socio-political implications. Well, I mean, I'm sure you know this book. I'm sure you have already read it. If not, it's like the Bible of the human biases. It's an excellent book. Thinking Fast and Slow by Daniel Kahneman. Well, let's move to explainability. Summarizing, the previous AI was based in decision tree systems, where you could trace where the outcome came from. Now, machine learning AI is based on the idea that the algorithm can learn from itself, from the data we give to it, and identify patterns without human intervention. These patterns are established by a neural network inside it, among its nodes. And the main problem, as you know, is that we cannot know the way the algorithm followed to give us the output, which is commonly known as the black box. Well, the good news is that in the last few years, computer scientists have started to use systems to explain how the system reaches the outcome. They are like explanation tools, model explanation systems that are able to explain how a system arrived to a decision. The problem is that these systems give us the factors used by the first system to arrive to the outcome of the case, but not a whole explanation with literature, with 10, 20 pages of human-made explanations, which allows us to intellectually understand the outcome. And in our judicial systems, and that can vary from jurisdiction, country, judge, in our judicial dispute resolution systems, we are used to receiving specific human-made explanations. And despite the fact that they are doing progress in this area by natural language processing, we are far from getting a literary explanation as those we expect to get from the judges. And this is a great limitation for the AI if we want to follow or maintain the current judicial mindset. Well, but at this point, we can wonder, what kind of explanation do we need? Could we maybe propose to change this mindset so that the explanation we expect be different? Well, AI is developing very fast, so in some years we could be living a very different reality. And connected to this point about the integration of AI in the judiciary, and considering the lack of a complete explanation we've just mentioned, we have to take into consideration how AI works. By doing the correlations between the patterns, AI makes a probabilistic approach to give us the outcome based in quantitative elements. But this approach may not take into consideration some qualitative elements, which in a quantitative point of view might be less relevant, but very significant for a human. And let me give you an example about this. Well, I don't know if you like tennis, but you are from Australia. And this is from Australia. Well, if you like tennis, You know that last January, Nadal and Medvedev played the final of the Australian Open. And as you can see here, the AI prediction before starting the match was 64 to 36% for Medvedev. But at the beginning of the third set, this is a picture of the beginning of the third set, Nadal lost the first two and was losing the third one too, 1-0. The AI gave 96 to 4% for Medvedev. And I guess, I don't have the information, but I guess that the AI prediction a bit later, some minutes later, was even worse for Nadal when he was losing the third set, 3-2 games, and Medvedev had 3 break points against him. But Nadal won the match and became the first tennis player in history in winning 21 Grand Slams. And the next day, I could find so many people in the media and the social networks saying that Nadal had beaten the machines. And that's why I think we have to understand how AI works. Because it's silly to say that Nadal beat AI. AI made a prediction according to the information, to the historic data it had. And this prediction was right. The odds were that Nadal would lose the match. However, there was a qualitative element that AI couldn't take into consideration, which was Nadal's strong mind. And in the end, Nadal won the match. And moving back to dispute resolution, what if we have a Nadal case? What if, considering the quantitative information, it is clear that the plaintiff, Medvedev, must win the case against the defendant, Nadal, because AI is not able to take into consideration the quantitatively relevant but qualitatively crucial information of the case? Well, in my opinion, if one day we would like to integrate a judge AI system in the judiciary, we have to necessarily foresee the possibility to appeal to a human judge so that he can weigh up these qualitative circumstances and not only the quantitative ones. And at this point, we can have a temptation. We could think that we would better always leave the last decision to a human judge, assisted by AI, providing him with drafts and an opinion. And it's true, this is an option. But I think that this response should be systemic. And in fact, we have to be alert of what is called the ironies of automation, the paradox of automation. It is very easy to fall in complacency or over-trust in technology. And if we are judges and we have an AI system providing us with drafts and opinions, it is so easy for us to follow AI's advice. And even having the formal control of the last decision, you don't exercise it. So the relevant point is having a meaningful control. We have to find a balance between relying on technology and having the meaningful control of the decisions. If you know this paper, it's an excellent paper about this. Well, let's finish with my presentation. Considering the war in Ukraine, it's not probably the best moment to cite Lenin, but the quotation is very good. There are decades where nothing happens, and there are weeks when decades happen. And a lot of things are happening nowadays with AI. Taking into account the evolution of technology, it's highly likely that in some years, we will see some experiences of judge AI, even in our own system. And in fact, there are already a few of them in progress. We have an enormous opportunity of improving the dispute resolution system, but at the same time, there are some risks we have to try to avoid. Today, we mentioned, for instance, these gaps, these hidden holes in the wings, this missing relevant information about the reality we want to capture in the dataset. And we also mentioned the human bias inside the data. And most of the times, we are not even aware of this bias. And by using AI, we can detect and correct some of these biases. But these are serious socio-political decisions that cannot be left in hands of the computer scientists. And we need multidisciplinary teams with different sensitivities working on this. So a big opportunity, a lot of risks, and let's adapt the dispute resolution system to a new technological reality. Thank you for your attention. Thank you. I don't know if you like my presentation with Nadal and the fight planes and so on. Thank you.